Very good afternoon to all the participants in this program. It's a pleasant Sunday, and in this special Sunday, we have reserved this for special program on constitutional vision of justice. So, in this program, we have very special person to guide us through this session, Dr. Balram K. Gupta. He is presently Director Academics, Chandigarh Judicial Academy, Chandigarh. Welcome all the law interns, law researchers, and some of judicial officers who have joined this program. So it is going to be very interesting for all of us. Fortunately, we have done this program for judicial officers earlier also. So for law interns, it is for the first time that we have started talking about Constitution of India. We have planned few more programs on constitution, but we'll start with constitutional vision of justice. To just cut short the time, I have already circulated the profile of Dr. Balram Gupta, which is very impressive, and it gives a rare privilege to all of us to be hearing Dr. Balram Gupta. Since last 5 years, Dr. Gupta is heading academics section of the Chandigarh Judicial Academy. And before that, he served as Director, National Judicial Academy from 2013 to 2015. And it was very good stint, and many activities were started for the first time in National Judicial Academy during the stint of Dr. Gupta. Dr. Gupta is a mixed blend of academics and law profession. So in both ways, he has excelled, and he has been practicing in constitutional law, and he has equal interest in academics also. In that capacity, he has served in university and has been visiting many universities inside India and outside India. And he has a stint at Cambridge also. So without taking much of your time, I would straightway now request Dr. Balram K. Gupta to start the conversation on constitutional vision of justice. Welcome, Dr. Gupta.
Thank you, Mr. Rajiv Gupta. Such a delight to be with you all this morning. In fact, to have a program on a Sunday morning is certainly not a welcome for particularly the young minds, the young students, the young interns as such. But if you are in romance with the Indian Constitution, even Sunday is no exception. And it is in that particular background, it was thought proper to have you all for this particular session in regard to the constitutional vision of justice. This particular aspect, justice, is something which is a concern of one and all. Justice, the nation is hungry, the people is hungry for that. And therefore, we need to actually get into this particular aspect as to what justice means within the ambit of the Constitution. My romance with the Indian Constitution started when I became a student of law in the year 1964. It continued when I started teaching constitutional law in the year 1969. It still continued further when I came to the profession in early 1991. And then in early 2013, when I went over to the National Judicial Academy and continuing with the Chandigarh Judicial Academy, this has been a beautiful journey, a romantic journey with the Indian Constitution. The first promise of the Indian Constitution to its people: justice, social, economic, and political in the preamble itself. It is manifest as such. This expression, justice, has also been used in the Constitution in Article 38, which is part of the directive principles, regarding the social order in which justice, again, social, economic, and political, shall inform all the institutions of national life. Once again, the expression justice has been used in Article 39A, which was added by way of 42nd Amendment to the Constitution in the year 1976. This particular expression, justice, is qualified by equal justice. That is, we need to have a system which provides equal opportunity to ensure justice, free legal aid. That was the aspect which immediately after the internal emergency, it was introduced by way of 42nd Amendment to the Constitution. And then the word justice has been used in Article 142 of the Constitution, to which I would be referring later in more detail as such. But that expression, justice, has been qualified by an expression, complete justice. And therefore, the recipe of the Constitution in regard to justice, threefold: social, economic, and political, all its manifestations as such, equal justice, and then complete justice. This is what has been weaved into the Indian Constitution in regard to this particular aspect as to what is the vision of the Indian Constitution in relation to justice. At this stage, let me refer to the Magna Carta of the year 1215. It says, justice is not to be sold, not to be denied, not to be delayed. That's the beauty of justice. And this all, in fact, is integral to our constitutional scheme also. Let us go a step further. What is the recipe of justice which has been incorporated in the Indian Constitution? Fundamental rights on the one hand, directive principles of state policy, and still the third component, relates to fundamental duties of the citizens of India. What a wholesome recipe which the Constitution provides so that justice could be made available to the people of India. Yes, fundamental rights, basic human rights ensured under the Indian Constitution. No right is an absolute right. Reasonable restrictions can always be imposed. Nothing can be absolute in any constitutional scheme. The balancing is very important. Not only the rights, let me go over to the fundamental duties. See, unless the citizens realize what are their duties, can we blend the rights without having the fundamental duties? In fact, initially, when the Constitution of 1950, there were no duties incorporated in the Constitution. In fact, jurisprudentially, if you have rights, you can't be without the duties. It was thought that probably the Indian citizens would themselves realize as to what their duties are. They thought that the laws which are already in existence and which are going to be incorporated would ultimately help us in having a system where people would realize what they can do legally and what they cannot do under the law for that matter. And therefore, in that particular context, what has been done is it was realized after the internal emergency that we need to have a separate chapter on fundamental duties. And therefore, once again, by way of 42nd Amendment, the fundamental duties have been incorporated in the year 1976. Which means over these years, virtually for the last 45 years, these fundamental duties have been in existence. We need to realize one particular aspect at this very stage. Fundamental duties have not again been made justiciable as such, in the sense, if somebody violates a fundamental duty, what is the consequence of it? It has not been incorporated. But that doesn't mean that the incorporation of the fundamental duties is merely a formality and not a reality as such. And therefore, in order to make justice wholesome, if I have a right and I come to the court claiming my right, I must be conscious of my duties as well. And I have been advocating one particular aspect, that if I violate my duty given and provided under the Constitution, should my fundamental right be recognized? Should it be upheld by the courts, the High Court, and the Supreme Court? I don't come to the court with clean hands. That is one basic requirement when I'm seeking justice from the court. I must come with clean hands. If I have violated a fundamental duty, obviously it means what? I am denying my right relating to that fundamental right as such. You would ask me, where is it stipulated in the Constitution? The question is, in order to do justice, when we are talking about the vision of justice under the Constitution, we have to harmonize many things. I destroy property when indulging in agitation. I get violent and cause violence to human body as also the property. And then I come on the other hand claiming a fundamental right of mine, freedom of speech, freedom of personal liberty. Certainly, I deny myself the legitimacy of claiming a fundamental right if I am violating a fundamental duty. And therefore, in that particular context, I have always believed and felt and argued that if somebody comes claiming a fundamental right, we have to look into the fact. Has he violated a fundamental duty? And if it is found, yes, it should be read as a limitation on the enforcement of his fundamental right. Jurisprudentially, fundamental rights and duties fundamental, they go hand in hand. And therefore, in order to do justice and realize the vision of justice under the Indian Constitution, it is time now to read the fundamental duties as limitations on the exercise of your fundamental rights. When I go into some of the fundamental duties, which I would look into a little later, certainly that would help us in ensuring justice. See, after all, the vision of justice means what? To do justice and also to remove justice. If we are looking to justice to one particular person, we have to ask ourselves, are we causing injustice to somebody else? And that is the actual vision of the Indian Constitution. This is an important aspect. I would look forward to questions in this particular realm. The third component, the directive principles, right from the beginning of the Constitution. These are directions fundamental in the governance of the state as it is provided under Article 37 of the Constitution. True, they are not made justiciable, but they are fundamental in the governance of the country. They have significance as such. These are directions to the state. Even if they can't be enforced through the medium of the courts, still not to be ignored as such. And how the Indian courts, the Indian Apex Court, has dealt with this aspect to realize the vision of justice under the Constitution. To begin with, it was felt fundamental rights are paramount. Directive principles are subservient to the fundamental rights. And therefore, in a situation where the two components come together, the fundamental rights would prevail over the directive principles. Now, in this particular context also, in due course of time, directive principles are to be read harmonizing with the fundamental rights. The harmonization of the rights and the principles assumes significance, and particularly in Minerva Mill's case, this component assumes significance. And therefore, when I talk of the recipe and the vision of justice under the Constitution, my focus is on what? The rights, the principles, the duties. They must be read together. They are the different ingredients of the final product. What is that product? Justice. And in that particular process, in preparing the ingredients into the product of justice, which actually is the vision of justice under the Indian Constitution, that they need to be harmonized. Fundamental rights, they are to be harmonized with the duties by reading the duties as limitations of the rights of the people. And state is to act. The fundamental principles of governance of the state are incorporated in the directive principles. After all, the rights are claimed against the state. And therefore, the courts have to look into how to harmonize the three fundamentals of the Constitution in order to ensure justice to the people, in order to ensure that injustice is removed and justice is done. This is very important. This realization of harmonizing is the actual basic context of the vision of justice under the Indian Constitution. Let me delve upon two small articles of the Indian Constitution to go further in the stream of justice. Article 14 says, state shall not deny equality before law and equal protection of laws. Simple, short, crisp. This one particular provision of the Constitution has got so much to do with justice in different situations. It's very good to say everyone to be treated equally. It's difficult to implement. It's difficult to realize the different contours of equality as such. Even God has not made everyone equal. And therefore, in that particular context, we have to see that equals to be treated equally, not unequals to be treated equally. Because if you treat unequals equally, then you are not doing justice. That's not the vision of justice under the Indian Constitution. Now, how India is a welfare state. In a welfare state, from good morning to good night, from birth to death and even thereafter, the state plays a significant role. It exercises immense powers. And therefore, the question that arises in that context is that what do we actually understand about the meaning and scope of Article 14 of the Constitution? Arbitrariness on the part of the state. Each action of the state should be sans arbitrariness. If the state acts in any given situation in an arbitrary manner, what is the consequence of it? Obviously, the state is discriminating. An action arbitrary qua me is in favor of the other party. My right to equality is violated. And on this component, thousands and thousands of cases under different situations have been pronounced by the apex court and the high courts of the country. So much about the right to equality. Such a small article, 2 lines only. Volumes and volumes have been written. Doctoral theses have been written. Books have been written on this particular right alone in order to understand and appreciate what is the vision of justice under the Indian Constitution, qua Article 14. Go a step further. Article 21 of the Constitution. Again, for the vision of justice, this one particular article, it says, no one shall be denied his right to life and personal liberty, except according to procedure established by law. Simple. You have your right to life, you have your right to personal liberty. And these important rights cannot be denied to you except according to procedure established by law. Now, when we come into the component of justice, the expression, the words, procedure established by law means what? In A.K. Gopalan's case, right in the beginning of the Constitution, it was interpreted to mean any procedure laid down under the law, if followed, you could be denied your right to life and personal liberty. Procedure laid down, follow the procedure, and you could be denied your right to life and personal liberty. This was a dangerous proposition. Anti-justice, against the vision of justice under the Indian Constitution. If the law is not reasonable, if the law is not just and fair, still I could be denied my right to life and personal liberty. Is that justice? Is that vision of justice? And therefore, this kind of a situation in ADM Jabalpur, we notice that it was only later on in Maneka Gandhi in 1978. The Supreme Court said procedure established by law means only such procedure which is reasonable, just, and fair. In fact, this was very significant for doing justice. Prior to Maneka Gandhi, in A.K. Kripak's case of the year 1970, the question arose not specifically with regard to right to life and personal liberty, but with regard to the application of the principles of natural justice qua state actions. State performs quasi-judicial functions, semi-judicial functions, adjudicatory functions in different situations. Of course, the principles of natural justice are applicable in order to do justice to the parties. Two basic principles. One, you cannot be a judge in your own cause. If you wish to do justice and you are interested in that particular matter, you are concerned or involved in that particular matter, surely you cannot do justice in that situation. And therefore, natural justice demands the authority deciding that matter must be free from bias, prejudice of any kind. And the second principle of natural justice, simply put, hear the parties before you decide the matter. In fact, Socrates, long time back, said, hear the parties conveniently, consider the matter soberly, answer wisely, decide impartially. These are components of natural justice. These are basic principles of natural justice. Why these principles? And why are they read into the Constitution? When we talk about procedure established by law under Article 21, and we say in Maneka Gandhi, they said, reasonable, just, and fair. The moment we use these three expressions, we are bringing in the principles of natural justice. We are bringing the due process of law. In order to do justice automatically, naturally, the natural principles of justice are required to be adhered to. When we talk about the vision of the Constitution, and when we look into the interpretation given to the expression procedure established by law, it certainly takes us to the realm of principles of natural justice, due process of law, of fairness, fair trial, basics. They are the foundation of justice. And this foundation of justice is integral to the Indian Constitution, reflects upon the vision of the Constitution. It needs to be really looked into that particular context. Simple words, procedure established by law, how they have been interpreted, how this expression has been used in different situations, in difficult situations, and how justice has actually and factually been done. That is an achievement of carrying out the vision of the Constitution through the medium of judicial review process. This is so far as procedure established by law. The right to life, personal liberty, how these two rights have provided justice in different situations. Right to privacy, right to live with dignity, and even after death, the right to dignified funeral goes on, continues. This is so significant as to how so many rights have been read into the right to personal liberty, into the right of life as such. And therefore, I have always felt the silences of the Constitution, may it be with regard to the basic structure of the Constitution, may it be with regard to procedure established by law, what it actually means. May it be with regard to the scope of the right to equality. May it be with regard to the scope and ambit of right to life and personal liberty. So many areas are silent as such. They are not specifically stipulated. How, with the passage of time, the vision of justice has been widened. Its sphere is now so large. Every human activity is included and covered in that particular process. And therefore, this particular way of how filling up the silences of the Constitution, they add to the durability and the longevity of the Constitution. Many of the recent constitutions did not even last as long as they took to frame the Constitution, to craft the Constitution. And I'm often asked, why so? Constitutions are crafted for generations to come. The US Constitution is as old as 1789. And see, it continues even today. Our Constitution of 1950 and the Constitution of 2020, what a difference. This shows with the change of times how the very concept of justice, very vision of justice under the Indian Constitution has been amplified. The areas which you could never think of are now integral to the Constitution, for that matter. It would be difficult to cover so many things as such, but the filling up of these silences of the Constitution and giving meaning to those silences of the Constitution in a very fertile, positive manner, the Indian judiciary, the constitutional courts have actually contributed to justice, to reach the people in different situations, hard situations for that matter. Now, one could go on with the other rights also. Probably in this particular session, it may not be practically feasible to do that. But let me refer to Article 142 of the Constitution. Complete justice. The apex court, the Supreme Court of India, can pass any order or a decree in a matter before it in order to do complete justice. Our framers of the Constitution, I must salute them. They could think of this also. It's a power. I should be using the expression power, in fact. The Supreme Court has been trusted with this trust of the people of India, that you pass any order or decree in order to do complete justice in any given situation. This article has been invoked. In fact, it has given rise, given birth to a new jurisprudence of justice, what is called complete justice. Yes, the duty of the courts is to do justice within the framework of the Constitution, within the framework of laws enacted by the Parliament and the state legislatures. That is what the rule of law requires. And therefore, in that particular context, what I actually look forward to is that in Article 142, different situations have come up. Yes, the Apex Court, the Summit Court alone, not the High Courts, not the District Courts, only the Supreme Court. This trust has been in that particular court. Supreme Court is the final court. Should the Supreme Court be handicapped if it is faced with a situation and if it finds that within this ambit of law, it's not possible to do justice complete in its ramification, should it be absolutely helpless in that situation? That's why I'm saluting the framers of the Constitution. They have ensured to the people of India complete justice in difficult situations, hard situations, that the Supreme Court can exercise this jurisdiction to do complete justice. I like to elaborate a little more into this particular realm as such. What exactly does it mean? Can the Supreme Court travel beyond the law itself, saying this law is not good law because it is hampering doing of complete justice, is obstructing of doing complete justice? One particular view is the Supreme Court has to see within the rule of law, within the statutory provisions, how to achieve the goal of complete justice. Yes, that is molding the law, interpreting the law with the aim of doing complete justice. It's something absolutely understandable, achievable, to be carried out. But then even constitutional benches have gone into this particular issue. It's a statutory provision on the one hand, constitutional requirement 142, the mandate of 142 is complete justice. Now, should the statutory provision become paramount and the constitutional mandate subservient? If the Supreme Court finds that a particular provision of the law is an obstruction, I ask myself, is that not violative of the Constitution? And if it is violative of the Constitution because of the mandate of Article 142, and that too to achieve the goal of complete justice, then in that situation, should the Supreme Court be helpless as such? I can understand if complete justice and other provisions, the rights given under the Constitution, question arises of a fundamental right as incorporated under the Indian Constitution. And the Supreme Court is finding itself in a dilemma. So far as the fundamental rights, the scope of them, as read under the Constitution and Article 142, they have to be read together. But a statutory provision, if it is obstructing the doing of complete justice, certainly in that situation, I would urge, and as the Supreme Court has exercised its jurisdiction in so many situations to do complete justice, we in fact are looking forward to a meaningful, wholesome, complete justice jurisprudence developing under the Indian system. This is something which you can export to other systems, constitutional systems. That actually is the vision of the framers of the Constitution, a vision of the Indian Constitution. Having said all this, all these rights and other aspects to make the aspect of justice meaningful, if there are no remedies to enforce these aspects of justice, justice is a basic human right. Even if there are provisions in the Constitution ensuring justice, social, economic, political, equal justice, complete justice, are there remedies provided under the Constitution to make it possible that this variety of justice is actually transmitted to the people of the country? Yes, look into Article 32, Article 2 to 6, Article 2 to 7, Article 136, and Article 142, also the Supreme Court exercising its jurisdiction. Though, of course, it is the Supreme Court alone which can exercise this particular jurisdiction. I'm not going into the details of these remedies provided under the Constitution. These remedies are beyond a large section of the country. Maybe the economic conditions, maybe illiteracy, and maybe certain other factors as such, that they can ill afford the luxury of invoking the jurisdiction of the civil criminal courts, the constitutional courts. And on the other hand, Article 39A provides for equal justice. If you don't have access to justice, if you don't have the means to go for justice, then in that situation, what happens? My response to that is, in 80s, we came forward, the Supreme Court came forward with public interest litigation, social action litigation. The locus standi was widened. Even if I'm not actually involved in a particular matter, I feel seriously concerned that people of this particular group are being denied their fundamental right, and they don't have the means to go over to the Supreme Court or to the other court. This remedy was brought in. Why? In order to do justice to the people. This is a remedy which has provided durability to the Constitution. In fact, durability to the concept of justice itself. If you don't have the access to justice, what is the use of justice? Vision of justice under the Constitution, if the access to justice, you can't reach the court. You can't make your claim for justice. This is such a significant development, which I feel strongly that yes, this is something in order to take it further for that matter. A lot can be said over a period of time. I look forward during the question answer session that this remedy has been used, has been also abused, misused also. And the courts have come forward in different situations to deal with those situations so that ultimately justice is done, is carried out, and not that it has to be absolutely closed down for that matter. You know, these are the developments, constitutional developments, which have added to the longevity of the Constitution. Amazing, but yes, the sustenance of the Constitution depends upon reaching the people for justice. And if the Constitution fails to reach the people access to justice, then in that situation, certainly something needs to be done. Not only that, legal service authorities in every state is doing what possibly can be done to ensure equal opportunity. In the sense, legal aid being made possible to the people as such. That is making justice accessible, reachable. I'm conscious of the fact we need more of Indian coffee houses than the kind of court system which is expensive as such. And that is why Magna Carta is relevant even today after more than 8 centuries. Justice is not to be sold, not to be denied, not to be delayed. Every possible effort, justice is being done. But the very fact you delay it, you are in fact denying it in that process. I'm conscious of the fact that how effort is being made in that particular direction. Then we have alternative dispute resolution situations, mediums for that. I would just basically touch upon mediation. Mediation is a tool now which is being used more and more, needs to be used more and more. And in that particular process, what needs to be taken care is, may it be the family court matters, may it be the domestic violence matters, may it be consumer matters, motor vehicle matters. such a variety of disputes. The high courts, even in complex situations, corporate matters, started referring the matters to mediation. Only yesterday I was reading in the paper, complex matters are being referred to. Mediation is a remedy, is a tool where no one is a winner and no one is a loser, and yet justice is done to the parties. That is the real kind of justice which is required to be done. And that is within the parameters of the law as such. We are not moving out of it. And therefore, I urge that this tool it needs to be used more and more. In the judicial academies, we are making absolute effort. The legal service authorities training the judges into mediation as such, a very welcome aspect of ultimately doing justice to the people for that matter. And more people are coming to that. It's less time consuming. Not, I won't use the expression cheap, but it is easily possible without any financial constraints as such. There are many other positive aspects of this particular remedy which needs to be explored in different areas in order to reach out the people for doing justice. Harold Lasky once wrote a letter to Justice Holmes, and he said, how much I wish if the people could realize that judges are human beings. Justice Holmes responded by saying, how much I wish if judges themselves could realize that they are human beings. It's a very important aspect of doing justice. Judges realizing that they are human beings. They are dealing with disputes of humans. They are dealing with disputes, problems of human beings. And that is why they need to develop scientific temper. They need to develop humanism. They need to develop compassion to do justice as such. I was watching a video only this morning. A judicial officer, maybe in the age group of 40 to 45, their family life was not good. The mother-in-law and the daughter-in-law did not get along well. A constant dispute. The mother-in-law was not being treated as she ought to be treated by the daughter-in-law, and the fights going on. The children would not even talk to the grandmother. The judge had no time to look into this situation. He got fed up with that situation. Decided to take his mother to an ashram, to an old people's home as such, to an ashram. She took her. He was helpless. He was not able to do. When he went to drop her, and the person, the caretaker of the ashram, he told him that you need to take care of her. Gave some money also to take care and look after her. Yes, sir. Even the caretaker was very upset. He said, Judge Saab, what is this? You know the entire situation. You can't do justice even to your mother? What kind of justice you must be doing to others in this kind of a situation? It shook him, but he had no option except that he left her in the ashram, came back home. He was very upset. Didn't go to the court for 3 days. And in a closed room, took no food. He was cursing himself that, what have I done to my mother? I couldn't even take care of her. A mother who looked after me and could make me a judge. And today, what that caretaker had told him shook him completely. Third day, when he opened the door, the lady wife was with food as such. He didn't take food. Told them that this is my divorce to you. And the children were told that all that belongs to me belongs to you. I need nothing, and went over to the ashram to be with the mother. It is at that stage when the lady wife and the grandchildren go over there and realized what was the situation. And the lady wife told the husband and the mother-in-law, I'm so guilty. I realize it. And she was brought back home. I've shared this only with the idea that attitude of judges, the mental makeup of judges, compassion, humanism are integral to justice. You can do all this if actually you imbibe these requirements as such. They are vital in that context. One more thing, then I look forward to the interaction. You know, today the judiciary is trusted by the people. Any situation, yes, let a judicial inquiry be conducted, investigation, judge be associated. The strength of judges so that they can do justice lies in the fact, trust of the people in judiciary. I remember Baba Rahim's situation in Panchkula. What kind of an ugly situation had arisen? How many lives were lost? So much of property was destroyed. Even the army had to be called. The CBI judge, under so much of pressure as such of the situation, not any other kind of pressure. How a judge should do justice in such a difficult situation? After the judgment was pronounced, the sentence was announced. I went over myself, met the entire district judiciary, and in particular, the CBI judge who dealt with this. And I asked him, what was going in your mind when you were to pronounce the judgment? And his answer was only one thing, that before anything happens, I should be able to pronounce the judgment. You know, that was the kind of confidence that he demonstrated. I told him that the way you have conducted yourself, you have built up the trust of the people in the Indian judiciary as such. You are actually the reflection of that. And therefore, judges need to be such kind of judges who can face different situations and yet do justice. That is actually the vision of the Constitution. I would urge the young interns that you have embraced the Constitution. I've shared with you the vision of the Constitution relating to justice. Make it part of your routine as such. Build up such attitude, cultivate such requirements which are necessary. You may be the future judges, you may be the future lawyers. The compulsory of lawyers and judges, they go hand in hand in order to really actually carry out the vision of justice under the Constitution. Be the future. Demonstrate that you have that particular mettle to withstand the difficult, hard situations and yet do justice. Your romance with the Constitution should be a continuous one. I'm happy to have shared my thoughts with you regarding the vision of justice under the Constitution. Thank you so much. I look forward to an interaction.
Sir, thank you very much for your wonderful conversation on constitutional vision of justice. Time is very short. We cannot do justice with the topic in this 1.5 hour or 2 hours of session. A lot many books, volumes have been written on vision of justice. Lot many articles have been written. So it's very, very difficult to have complete conversation on constitutional vision of justice. But you have shown the way, and they can build upon it, and they can study more to realize what is actually the constitutional vision of justice. And your conversation has been very fruitful to all of us to understand what actually Constitution enjoins upon all of us to do. And one thing very important, constitutional, this mandate of duties, fundamental duties. So when we talk about fundamental rights, we forget that there are fundamental duties also enjoined upon by the Constitution. So when we talk about fundamental rights, so correspondingly, we have to talk about fundamental duties as well. So thank you very much for your wonderful discussion on this vision of justice under the Constitution of India. There are a few questions in the chat box and Q&A box. I would like to take the participants on board so that it's a two-way conversation and not just one-way conversation.
Good, good.
Just
I'm happy
try
with that.
To take this question live. Just I'll try to get the participant on board. First participant, Mr. Divaksh Davar. I'll just unmute him and try his question live. Yes, Mr. Divaksh, you can ask your question.
So first of all, I would like to tell you that it's a great honor for me to listening to a lecture from you. I am from Chandigarh only and currently studying at your alma mater, Punjab University Law Department.
Good.
So my
Good.
question,
I'm happy
so my,
about that.
so my question is, you
Yes.
told that one of the canons of natural justice is that you cannot be a judge in your own case.
Yes.
But last year only, one judge of Supreme Court broke this rule as he was one of the judge in his case, the case being related to sexual harassment. Doesn't these cases set a bad precedent in terms of the constitutional vision of justice?
Yes. You know, this is an issue which concerns one and all as such. The fact remains the principle of natural justice, you cannot be a judge in your own cause. To what extent that principle was being violated, actually violated, when the matter was considered by another bench as such, various aspects come into that play. I would only say it was an unfortunate situation and didn't augur well to the Indian judiciary as such. Let me also add one particular expression to it. In any system, at some time or the other, such difficult situations come. People understand them. They realize what actually it is. Even if it was not adhered to in actual reality, the damage which is done is understandable. And therefore, it doesn't make a dent to the principle as such, and it doesn't make a dent to the vision of justice. One particular situation, it happened. And this is not the only situation. In 7 decades, many situations have arisen. I would only say they are aberrations, they are exceptions, but the fact remains principles of natural justice are universally applicable. And my advice is you must be punctuated with, you must be drenched with principles of natural justice if you wish to do justice, maybe as a lawyer or maybe as a judge. That's my response to this.
Thank you, sir.
Thank you very much. Now, next participant, Mr. Siddharth Jasrotia. I would just unmute him and take his question. Yes, Mr. Siddharth, go ahead with your question, please.
Good afternoon, sir. I hope I'm audible.
A
Yes,
little louder.
very much.
Yeah, so sir, I had two questions.
Yes,
Firstly, you mentioned that there has been a transformation from litigation to alternate dispute resolutions. Now, if we
yes,
see litigation, it is a very masculine notion of fighting a case, whereas alternate dispute resolution are more towards peaceful compromise. I personally align with this view. However, there are some contrary views which people say that alternate dispute resolution actually do not adjudge on the legal matter. They are more towards compromising and hence are not a good legal precedent. Kindly comment on that. And my second question, sir, is that can you tell us what is the relevance equity in Indian justice disposal system? Like in earlier UK Chancery courts, equity courts were given high importance. How do you think that Indian court should perceive that?
good, good. Taking up your first question, you are right. Litigation, legal complex situations are not meant to be compromised. not meant to be resolved through compromise process of mediation and other alternative resolution. I totally. That is why my reference was mediation can be used and should be used meaningfully in certain domains only. Highly litigative aspects based on law as such, they need to be taken up by the courts, undoubtedly. But there is a large chunk, if I use that expression, of cases, maybe the family matters, maybe the consumer, in fact, the latest Consumer Act or the amendment as such, which actually is yet to come into force after the rules are framed. The matter has to go to for mediation first. The consumer court would refer to mediation, and then after they have dealt with the matter, if it couldn't be resolved, comes back to the consumer court for that matter. Similarly, the motor vehicles, those are areas which need to sit across the table, discuss. In Motor Vehicle Act, the compensation that you receive, if you receive them after 20 years, after a litigation from the lowest to the highest court as such, what is the use of that? Children could not be educated. They couldn't be given education. The handicap is such. And therefore, in that particular process, mediation or alternative dispute resolution is a remedy for certain domains and not highly complex legal situations. That is one. The second question of yours, what is the role of equity in vision of justice? Good that you are asking. Article 142, it is the equity aspect which would be more important. What is equitable in this kind of a situation? And there, the actual wording, the technicality of law has to be punctuated with the equitable concept of the situation in order to do complete justice. But I would say it's a situation. Justice versus justices. Certain justices, they bring in equitable elements as such. And therefore, it's blending justice with equitable concepts, not only in situations which demand complete justice under Article 142. Yes, justice according to law, we say, is the best kind of justice. We don't want law of the jungle. We want justice according to law. But here also, see what happens. How you read a particular situation or a particular provision of law, and how that helps you ultimately in reaching justice being done. And therefore, Indian Constitution, Indian judges are not divorced from equitable concepts as such. Yes, it's the law which prevails. But there is always a gap between law and justice. in a given situation. It's the equitable concept of justice which would fill in the gap, the space between justice and the law. There's always a space as that. That is how I would respond to this.
Thank you, sir. Now, next question is from Mr. Yunis Ahmed. I am unmuting Mr. Yunis Ahmed and he can ask question. Mr. Yunis Ahmed.
Good afternoon, sir.
Yes, good afternoon. Please ask your question.
So I'm a law student from Kashmir University, sir. So you talked about sir ADM Jabalpur.
Sorry,
case.
could you be a little louder?
Am I audible, sir? No. Hello.
Audible, sir?
Yunis, you are audible, but if you could be a bit louder, it would be good.
Hello.
Or Mr. Rajiv Gupta, you could take the question and ask me. I would respond to that.
Okay, let Mr. Yunis Ahmed first ask the question. If it is not audible, then I'll repeat it for you, sir. Yes, Mr. Yunis Ahmed, go ahead. Okay, his question appears in the chat box also. I'll take the question from chat box.
Yes.
The question is, you have talked about ADM Jabalpur's case, but recently in the Supreme Court, certain cases of importance have not been taken up on priority. So how would you respond on that? The cases which involve the liberty or fundamental rights of the people, they were not taken up on priority.
See, let me put it this way. We are passing through difficult times. Physical courts are unable to meet as such. We are going through the process of virtual courts. Virtual courts, as the Honorable Judge Justice Dhananjay Chandrachud has said, are a poor substitute for physical courts. And therefore, in this kind of a situation, what is maximum possible is being done. Yes, sometimes certain cases which should be taken up on priority may not have been taken up as such. But that is the situation through which we are passing as such. And consequently, I would not actually, ADM Jabalpur was a different situation at that time. It not to be equated with that. And we know what a change has taken place after ADM Jabalpur. It is that change in which that we have been able to go that far and what we have achieved. I would only add a caveat. It's not possible to say that everything is well in every situation. After all, human beings are dealing with manning the courts as such. The judges are also human beings. And therefore, they are not computers. And that is why there is a need to develop humanism, compassion, and various other positive attitudes which make the personality of a judge. Please, the next one.
Next question is from Mr. Udit Malik. I am unmuting Mr. Udit Malik. He can ask his question. Yes, Mr. Udit Malik, go ahead, please.
Good afternoon, sir. This is It's Malik. So my question is like
I'm
just
unable
like
to hear it.
hello. So am I
Yes,
audible?
you could be a bit louder, Udit.
Yes, sir. So,
Mr.
sir,
Kuldeep,
my
could you be
question,
a little louder?
yes, sir, just like justice delayed is justice denied, even court has observed that even justice hurried is justice buried. So my question is, sir, what are your views considering the fact that we have a pile of cases pending in
Mr.
India
Gupta, I'm not
right
able
now?
to make out what you kindly.
Yes. Uh, the sum and substance of Mr. Udit's question is that there are two theories. One is that justice delayed is justice denied, and another theory is justice hurried is justice buried. So, what are your views? How to balance it? Because there are lot many cases, piles of cases in courts to be attended by the judges.
Yes, we are faced with both aspects. There are areas, loads of areas as such, and therefore it takes time. And there are also at times that keeping in view that so many cases, areas as such, that you decide cases in a hurry and not devoting that much of time which is necessary for fairly dealing with certain matters. This aspect needs to be balanced. There's no doubt about that. Question is case management, court management. The judges have to tune and train their minds in regard to that. Time management is equally important in that particular process. The quality of justice must not suffer. And therefore, in that particular process, you have to adopt various ways and means. For instance, in a particular case, the written arguments can also be sought in order to avoid delay in the matter, in the sense, in the court, the case is argued for a short time, let's say for half an hour. The lawyers feel that something more needs to be. Yes, the judge can ask that you give your written submissions. It would save time. But equally, judges have to be prompt in delivering the judgments also. There is pressure of work, there is no doubt as such, but balancing needs to be done. Tuning is to be done. This is what needs to be learned by the young interns. Lawyers and judges, how well they perform. Their commitment to the Constitution. And with that commitment, certainly, if there is delay in deciding a matter, this is not doing real justice. And if you do it in a hurried manner, you are not doing justice to justice itself. Therefore, balancing is required. These principles have always been in existence and has been the malady of many of the systems. And that is why we are thinking of various ways and means how to reduce the workload so that the judges can devote more time to each case and come out with quality judgments in that context. Thank you.
Thank you, sir. Now we have a question from a participant with credentials RS 3465120. Name has not been mentioned. So I'll unmute the person and let him ask the question and tell his name also. Yes,
Hello.
please go ahead.
Hello, good afternoon, sir. My name is Randhir Singh.
Yes.
Am I audible, sir?
Yes, you are audible.
Yes, thank you, sir. Sir, my question is, as far as we have seen that judiciary has by and large remained independent and independent of the political influences, but the institution of police has succumbed to the pressures of their political bosses by their respective state governments or the central government. So my question is, the reforms which you think needed to be brought to clean and pure the police institution and the police reforms, you think?
Please. See, this question is most relevant in the present context. Question is, judges need to be firmer. After all, first of all, look into one aspect. Judges are also part of the system. If the system itself is drenched in kind of certain situations, to expect the judges to be absolutely out of it, though we want and wish and trust that. That is why even today, you must have read in the newspapers in the morning itself that judges have to conduct themselves in a manner where the trust and confidence of the public continues as such. Apolitical. Yes, the institution is totally apolitical, ought to be. But then, in such a large, complex situation, I would only say this. We are committed to the Constitution. And this commitment to the Constitution is not a question of deciding cases according to your own conscience. It was being said that I decide cases according to my conscience. I believe this, and therefore I decide the case like this. Your commitment is to the Constitution. May you be a lawyer, may you be a judge. That is why I said your romance has started with the Constitution. Constitution is the holy scripture. It's the Bible, it's the Gita, it's the Guru Granth Sahib. I always advise, particularly the district judiciary, keep a copy of the Constitution on your table at home and in court. And it would be a reminder to you what is expected of judges. What is the commitment of a judge? Difficult times come, difficult situations come, but then judges have conducted themselves in the best possible manner. Make those situations as your role model. Exceptions should not bother your mind, I'm sure. That is the passing phase as such. Yes.
So thank you very much. Now, there are a few questions from our senior district and sessions judge, Ms.
Yes.
Bala Jyoti. I would unmute her and she can.
Please.
Actually, she has from two devices. Let me see how can this be done.
Hello.
Yes.
Yes, ma'am. Please go ahead.
Good afternoon, sir. My query is twinfold.
Yes.
I would like to ask, since faith in judiciary is as everybody said, is quite eroding. So I say how to check that erosion of belief and trust in judiciary as myth is being exploited. And despite our potential constitution, still many people are striving hard to have access to justice, particularly in COVID times, and how to assure them about availability of law for them. This is all I want to ask, sir. And
But particularly about the COVID time, what is exactly the question?
sir, I say that since our constitution is a potential one, it has granted many rights, fundamental rights, duties, as well as
Yes,
directive principles for
yes,
welfare of the people. I
yes,
say that many people are still striving hard to have access to justice,
yes.
particularly in COVID times. Maybe they are not IT friendly or any other reason. So my query is how to assure them that about availability of law for them.
Please. Good that you are asking about this. Erosion part.
Yes, sir.
Now, let me be very honest and straight in regard to this. I would only urge and say one thing. Each one of us is answerable
Yes,
to
sir.
oneself. You would ask me, if I find something happening before me, can I close my mind and eyes altogether? I would agree with you, it's not possible.
Yes.
Even if you keep your mind and eyes open, you see what you hear, doesn't mean that you have to be swayed by that. Have your own mind, have your own concept of constitution, have your own commitment to the constitution. If the majority, a large majority, is committed to the constitution, certainly I would urge in that situation, we would be marching forward and building up the trust and confidence of the public in the institution of judiciary. Our goal is to build up the trust and confidence of the public. I'm answerable to myself. And therefore, I should not do anything which would erode the system in one form or the other. And that's why I'm urging particularly the younger people, right from beginning, be committed to the Constitution. And let the Constitution be your companion throughout. That is one. Coming to the COVID times, I'm conscious how the human bodies, dead bodies, were being really treated as such. It was a shame. I am conscious of the fact the labor, what kind of a situation it was. Domestic violence cases increased manifold. Many difficult situations, particularly the fundamental duties, fraternity, assuring the dignity of the individual. All these aspects were in the forefront during all this time as such. And that is the reason why I urged that during this particular period, the duties of the people of India, the citizens of India, were in the focus. I have personally talked to many judges at the High Court level and even in the Supreme Court level. And There is a positive thinking of reading the fundamental duties as limitations on the fundamental rights. You know, like it took time to harmonize fundamental rights and directive principles, I'm sure we are marching now forward. And the lessons that we have learned during the COVID-19 period are a barometer for harmonizing the fundamental rights and the fundamental duties also. I would say, in addition, that yes, difficult for the courts to function with a scare in your mind. Could one discharge one's responsibility, duty effectively? We have all gone through that particular process. At the Judicial Academy level, we are not able to have physical training. You are not able to hold the physical courts as such. And that is why I say, and I lectured on this aspect also, the judicial mind and the COVID-19 period. You know, you have to be free from stress in order to do justice, in order to implement and decide cases in accordance with law. This situation had been a stressful situation. I would end up by this question as such, adding only, we are looking forward to better times. And the lessons that we learned, we should be able to take care in that particular context. The cases must have mounted up. And I'm sure when we open up, and particularly the physical courts, the areas would be stark before us. The task is gigantic, but I'm always positive. My judges, our judges, would certainly perform that well to deal with the situation. Please, thank you for this question.
Thank you, sir.
Yes, thank you very much. Now this next question is from one of the participant, Nabila. I'll just unmute her.
Hello.
Yes,
Hello.
Nabila, go ahead.
Sir, am I audible?
Yes, if you could be a little louder, I'll be.
Hello. So basically,
Yes.
hello.
Mr. Gupta, you will have to help me with this question.
Yes. Nabila, go ahead. You ask your question. If we are able to hear your question, I'll
Okay.
request Mr. Gupta to respond. Yes, please ask.
So basically, my was keeping in view the current 2020. Are the principles of the complete justice, a complete reality? Hello.
Ms.
Yes,
Gupta, could you just repeat this question?
yes, complete your question, Nabila. Then we'll respond.
So I'm not able to.
Okay. I'll see the question is in the chat box.
Yes, sir.
I'll see it in the chat box. Just a minute. Give me a minute.
Mr. Gupta, can you excuse me for a minute? I'll just get back. Just one moment.
Sure, sir. Sure. Meanwhile, I'll check the question. In the meanwhile, just I'll tell to the participants, especially our law interns, that uh, we wanted to have two programs in a week, and I had taken feedback from you. And most of you, almost 80% of you said that Saturday and Sunday would be fine for having two programs. So then about timing, you had preferred timing between 3 to 5, 4 to 6. But this is a program, one program which we are doing in the morning. So most of our
My
programs.
apology for
Please,
my
sir.
apology.
So most of our programs, I was just telling to our participants that most of our programs on Sundays would be on in the evening itself. So this is one of program where we are doing it in the morning. So other programs that you had desired, all have desired that 3 to
I
5
mean,
or 4 to 6 period would be fine. So
some of
next
them have
program
not been
will
able to join. What?
No, just actually I was talking to because I got some time. I was talking to them that they had desired the programs to be on Saturdays and Sundays. We had taken feedback from them, and most of them had asked for programs on Saturday and Sunday. So this
My
is one of program which we are doing in the morning session, and the other programs we'll be doing in the evening. So yes, the question from Nabila was, how can
yes,
the court create a balance between the principles of complete justice and at the same time function within its statutory limitation? This is the question, sir.
yes. You know, this is a difficult task. Question is, complete justice is one aspect of it. First of all, the court has to make the effort how best they can do complete justice within the statutory provisions as such. You know, you can always go to the spirit of the provision. Take, for instance, Section 13B of the Hindu Marriage Act. Divorce by mutual consent. Cooling period of 6 months is stipulated. Now, many cases have come up before the Supreme Court under Article 142. And in order to do complete justice, immediate mutual consent divorce is required. 20 years the litigation is going, marriage has absolutely broken down, there is no possibility of reconciliation at all in any situation whatsoever. Now, what is the spirit of this particular provision of 6 months cooling period? The idea is divorce not in a huff. At a particular given moment of time, the parties think and decide to mutually part their ways. And they're given 6 months, normally during the normal situation as such. Think it over. If you can be together, that's the best way out as such. That's the spirit of 6 months. Now, if the Supreme Court is satisfied totally and fully that giving this 6 months is just delaying, is a torture, it would make the situation much worse. Go to the spirit of the provision. And there is nothing wrong in doing complete justice. Letter and spirit, blend the two together and waive off that particular period of 6 months for that matter. That's a difficult situation, and the courts have done it. Supreme Court has done that. Question is, the law is a limitation on you. The moment you find that limitation is obstructing you from doing complete justice. Now, to my mind, you have, even I would go to that extent, the constitution provision, the constitution mandate of complete justice has to prevail upon the provision statutory for that matter. It's a constitutional provision. That's a statutory provision. The legitimacy of a statutory provision depends upon the constitutional provision. The courts have not gone to that far to declare a particular statutory provision to be unconstitutional. But they have actually and factually gone to this extent. The constitution provision is to prevail. The mandate of the constitution is to prevail. And therefore, say justice according to law, for instance, procedure established by law. That's the best example. If the court finds the particular procedure laid down is not reasonable, just, and fair, in order to do complete justice, certainly that procedure would be set aside as violative of Article 142 also, because it is hampering in doing of complete justice. I think this particular provision is a very potent provision of the Constitution. In fact, I go to the extent of saying complete justice is a part of the basic structure of the Constitution now. It has assumed that significance. And this complete justice cannot be taken away. This provision of the Constitution, to my mind, cannot be taken away, even by an amendment of the Constitution. That's the beauty of this. You know, you must do every possible thing to do complete justice. To do justice, and in many situations, complete justice. That's the vision of the Constitution. Vision of complete justice of the Constitution is in fact the basic structure of the Constitution. Thank you.
So thank you very much. I think I'll take this last question from a participant, Malika Rashid Wani. If she is still there, I'm unmuting Malika Rashid Wani. She can ask a question.
Good afternoon, sir.
Yes, good afternoon. Please ask your question.
Sir, actually, it's a pleasure being here. I'm from Central University of Kashmir. So my question actually is, it's just a simple question. As we all know, from previous year, August, we have been denied right to internet. So don't you think, right, it is affecting our right to education, because we all know, especially in this time of
I'm not
pandemic,
able to.
especially in this time of
You
pandemic.
will have to help me out again.
Yes, yes, I'll moderate the question. Yes, please continue your question, Malika.
Yes, sir. Especially in the time of this pandemic, as everything is going virtually. So don't you think that our right to education has been denied? No doubt 2G internet speed is there from past few months, but it has been a year, over a year, and I think more than a year, that high speed internet, our high speed internet is not there. So don't you think it is affecting us in one way or the other, or our right to education? And this is injustice, as sir already mentioned a lot about justice, which is provided in the Constitution of India.
Okay. Uh, Dr. Gupta, the question is,
Yes.
although Supreme Court has already ruled on it, but the question is very pertinent, and probably most of us would like this to be answered. Like you already know that we are facing internet problems in Jammu and Kashmir. So that way, our right to education is also being affected, and lot many difficulties are being posed by slow.
Please say that again. Please say that again.
Okay. Uh, as you know that we are facing internet difficulties,
Yes.
like in one of your session also, because of internet difficulty, there was lot many problems in that program. So we all are facing these problems of internet difficulty. Okay. I think we have lost connection with Dr. Gupta. Let me see if we are able to get him back. Okay. Malika already, yes, Mr. Gupta is back. Are you hearing Dr. Gupta? Dr. Gupta, can you hear us? So these are okay. Dr. Gupta is on call. Just a minute, give me. Okay. So we are not the ones who are facing internet difficulties. Internet difficulties at Mr. Gupta's end also. Yes, we got your video, sir. Can you hear us? So the internet difficulties are playing their role. So we are not able to take this question to Mr. Gupta. So yes, already Supreme Court has ruled on it, and it is now for the authorities who are at the helms of affair to see the difficulties, understand it, and restore the internet to its full potential. So already, since the judgment is already there from the Supreme Court, nothing else can be said on it. But only thing is to for the authorities to act on it and take a call on what the Supreme Court has already ruled. So I think we have taken all the questions, and there are no more questions in chat box and the Q and A box. There is difficulty at Mr. Gupta's end also. So I don't know whether he is able to hear us, but I would uh, uh, thank Mr. Gupta for a wonderful presentation, wonderful conversation on the subject, which is very, very pertinent subject, and it concerns all of us. So it is not that constitutional courts are only repositories of protection of fundamental rights, but at all level, judges from the municipal level up to district judges, we all have constitutional duty to render justice, and justice according to the letter and spirit of the Constitution. So thank you very much, Dr. Gupta, for your conversation on it. And it has enlightened all of us on the principles on which the Constitution works. So thank you all the participants. Thank you very much for your patience on this Sunday, that too in the morning. So thank you very much. With this, I would like to close the program and see you on next Saturday for having this program, next program. in a series of programs on career in law. Thank you very much. Thank you all.